Good afternoon. My name is Martin Grayson. I'm the author of The View from the First Chair, a book about how to be a litigator, how to think like a lawyer. In this series, we've covered a number of topics ranging from pretrial discovery through trial itself. I'd like to talk now about thinking on your feet in the courtroom. This might be at a motion, it might be a trial, but whenever it occurs, there are occasions when you're caught short, you're taken by surprise. What do you do in that situation? As an attorney, you've probably sat in courtrooms and watched other attorneys before the judge hit with something they don't expect. Some of them react like a deer in the headlights, some of them react professionally and cordially, some of them have the perfect response. You want to be the attorney with the perfect response. But how can you do that when you don't know how to prepare for everything? Well, the first bit of advice I have, of course, is prepare as thoroughly as you can. Never walk into a courtroom without having a very good idea of what the judge is going to do and how she is going to do it. You can do that by just assuming you're the judge. How would you handle this particular motion, this particular hearing, this particular witness, this particular testimony? That'll give you a good first clue. But even so, the day will come when the judge will ask you a question for which there is no answer on earth. What do you do in that situation? This happened to me several times. I've seen it happen to other attorneys. Several times it's actually been a mistake. I'll give you an example. I'm arguing a motion for bifurcation. Offshore platform explosion, we want to bifurcate liability and damages for obvious reasons. I'm arguing, opposing counsel is arguing, and at one point the judge turns to me and says, "Well, Mr. Grayson, what about the ruling in Wizard v. Oz?" Wizard v. Oz? I thought that was a local Kansas case involving a lost dog. And here the judge is asking me to comment on a case I've never heard of. What do you do? There are several things you can do if you think about it. First is, and I advise this in every case, you apologize. You say, "I'm sorry, Your Honor, but I did not encounter Wizard v. Oz in my research. I do apologize to the court and to opposing counsel. If Your Honor would be so kind as to give me some of the indications in that case, or better yet, allow us 3 days perhaps to rebrief on that topic, I would be more than happy to address it. But again, Your Honor, I apologize that I am not prepared to discuss Wizard v. Oz at this point." Or if you have encountered Wizard v. Oz, but thought it was unimportant, again, apologize and admit to the court, "Yes, Your Honor, we did encounter Wizard v. Oz in our research, but to be frank, we thought it was about a lost dog in Kansas that had no bearing on this case at all. And so I'm not prepared to comment. If Your Honor would permit us more time, go to the library, go to law school, whatever you think is necessary, but at least you're talking, you're responding, you're making noise like a lawyer, and that's what's important." One time that happened to me, the judge asked me about a case of which I had never heard. I apologized, asked for some more time to research, and a few minutes later the clerk, this is in federal court, clerk came over, whispered in the judge's ear, and the judge turned around and said, "I apologize, counsel. I was thinking of another case on my docket that's coming up after this one. Wizard v. Oz is not a problem here." Which is the best possible result because you were courteous, you were polite, and you weren't making a mistake as he thought you were. But the key here is to think on your feet. A, you have to be prepared, and B, you have to be prepared even if there is no response. You apologize, you ask for more time, you somehow wiggle off that hook, but you sound like a lawyer while you're doing it. That's thinking on your feet.